Good afternoon, and welcome to September's Planning Lunches at Noon webinar, brought to you by the Office of Planning and Development at the New Hampshire Department of Business and Economic Affairs. Today's webinar is titled Changes to Planning, Zoning, and Building Code Laws in 2025. My name is Noah Hodgetts, and I'm a Principal Planner in the Office of Planning and Development at BEA. Here is a reminder of how to use the Microsoft Teams webinar controls. Please put your questions in the chat, and we will do our best to answer them throughout the webinar. Due to the high number of people in attendance on today's webinar, we're not going to be able to unmute folks during the webinar, but we'll do our best to answer questions in the chat during the webinar, and then we'll also have some time, hopefully have some time for questions and answers at the end of all the presentations as well. The speakers for today's webinar include myself, Tim Corwin, who is the Deputy Planning and Development Director for the City of Lebanon, Michael Hagan, who is the Plans Examiner, Floodplain Administrator, and Assistant Emergency Management Director for the City of Keene, and Philip Trowbridge, who is the Land Resource Management Program Manager at the New Hampshire Department of Environmental Services. Here is the agenda for today's webinar, summarizing all the different bills that we are going to go through. Don't feel like you need to take down detailed notes on everything. The slides will be available on our website afterwards, and we'll also make sure to send a PDF version of the slides to everybody as well. Most of the slides do also include, if you're viewing them online, include hyperlinks to both the final chaptered versions of each of the bills we're going to talk about, as well as each of the statutory references. And as I just said, if we do run out, we will have time for questions at the end. If we run out of time, you can always reach out to myself or any of the other speakers. The email addresses for all of us are listed at the end of the presentation, and we'll also make sure to post on our website any answers to any unanswered questions as well. So first, Tim and I are going to go through the different planning and zoning statute changes from this past legislative session. The first bill I'm going to talk about is House Bill 2, relative to state fees, funds, revenue, and expenditures. For folks that aren't familiar, House Bill 2 is the trailer bill to the state budget. We are just going to focus on a couple of sections of House Bill 2, 209 to 214, which is the Partners in Housing Program. The Partners in Housing Program was originally part of House Bill 572, which got incorporated into House Bill 2 in a Committee of Conference process. It's a new process for municipalities to designate and expedite permitting of municipally owned land for residential purposes. So the bill creates a new process that begins with the governing body as outlined in RSA 4111-A, sending a list of municipally owned property to the planning board that in its judgment is appropriate for development for residential use, not including tax deeded properties. Once the governing body, the Board of Selectmen, has done that, the Board of Selectmen can then send that list of properties for residential development to the planning board. The planning board then, as detailed in 674:1, will take that list and designate any of those properties that it recommends as appropriate for development as a residential use by the select board. And it then sends that list that it deems appropriate, those properties and the description of those properties to our office, to the Office of Planning and Development. And then after the planning board has submitted that list to our office, to OPD, the local governing body, again, usually the select board, may then vote to authorize these properties qualify for expedited review and approval pursuant to RSA 676:4. Roman numeral 3, which is the minor subdivision expedited review process statute. Or if the local legislative body, the voters, have already voted to authorize minor site plan review, typically we think about this as known as technical review committees pursuant to 674-43, then all those projects already have plenty more than already has the authorization to basically go ahead and subject those properties, those municipally owned properties that it wishes to develop housing on to that minor subdivision review process, and it doesn't need to receive any additional authorization from the governing body. And this process is kind of comes out of the city of Lebanon, which is currently in the process of developing five cottages on 3 parcels of municipally owned land, previously municipally owned land on Barrow Street. In the city, there's a picture of one of the cottages there on the upper right. So the second part of the partners bill is that, as I said, is that it creates a new requirement for BEA and OPD to compile a list of the descriptions of all municipal and county-owned property deemed to be appropriate for residential use as submitted by the municipalities and make it into a public list with the end goal that these properties would then be eligible for potential funding from a Partners in Housing program that would be part of the BEA Housing Champion program. The legislator chose not to appropriate any money for the Partners in Housing program in the FY 26-27 state budget. So there's no funding to go towards the development of those properties into housing right now, but municipalities are still welcome to send OPD the list. And we will begin putting that list on our website. The final thing that House Bill 2, this section of the Partners in Housing portion of House Bill 2 does, is it explicitly authorizes legislative bodies to adopt pattern zoning, as the city of Lebanon has also done in 674-43. Pattern zoning provides permit-ready designs with appropriate zoning and regulations to speed up the process of building high-quality infill housing that's compatible with existing homes in the neighborhood. And the statute also says that to meet the definition of infill housing, projects must be residential development constructed on vacant lots interspersed among the lots with existing non-vacant development. And here's a picture of what the pattern zones look like in the city of Lebanon in one of the renderings. Now, Tim is going to talk a little bit about House Bill 92.
Thanks, Noah. House Bill 92, as originally introduced, would have prohibited zoning board members from also serving as planning board members, period, and vice versa. But as adopted, the bill instead focuses on zoning board recusals in certain circumstances. The language is when a member also serves on a planning board, that person shall recuse themselves from voting on matters previously decided by or pending before the planning board in a quasi-judicial capacity in which the member participated as a voting member. The couple things to note that this seems to make sense in the context of administrative appeals, so that if the planning board makes an appealable determination and it's appealed to the zoning board, it would make sense that you wouldn't have a zoning board member sitting on a matter under appeal that they participated in making. But the language is more broad than that. It just says matters previously decided, and so I think the way to read that is broadly, and so that it would include any aspect of an application that may be heard by the zoning board for whatever reason. So, for example, if a project needs a local wetland approval, a wetland impact special exception, and that's applied for to the zoning board during or after the planning board, say, site plan review. The zoning board member if there's a zoning board member who's also sitting as a voting member on the planning board application, that zoning board member needs to remove themselves or recuse themselves from hearing the related wetland application. Curiously, though, it's that the duty to reciprocate, or sorry, the duty to recuse is not reciprocal. And so, for example, if a project requires a wetlands permit, say a special exception from the zoning board, and that's obtained prior to submitting the project to the planning board for site plan review, if there's a planning board member that had sat on the wetlands application as a zoning board member, they do not need to recuse themselves under this new statute. And in fact, there was language at one point in the House amended version of 92 that would have required the planning board member to recuse themselves from sitting on a planning board application that they had sat on. They had sat as a voting board member on the zoning board for a related application, but that was not included with the final bill. So it's not. I'm not sure what the policy reason is for requiring recusal, outside the context of administrative appeal. But if there is that policy rationale, it's not clear why it's not reciprocal. In other words, if a special exception is needed for a project that also requires site plan review under this bill, if that special exception is obtained before the planning board reviews the application, then a planning board member who also serves as a zoning board member does not need to recuse themselves. But if the special exception is obtained after site plan review, to the extent your regulations allow that, if the wetland special exception is obtained after site plan review, the zoning board member does have to recuse themselves if they also sat as a voting member on the planning board application. So it's not clear what the policy is. One other confusing aspect of how this bill was drafted relates to the last part of the sentence, which refers to a member that participated as a voting member. But it probably should be read as participated or is participating as a voting member. So it's not just applications before the zoning board that come after the fact. It's applications that come before the zoning board that are concurrent with planning board applications that are currently under review. Noah?
Great. Thank you, Tim. The next bill, planning and zoning bill we're going to talk about is House Bill 168, relative to including municipal public works facilities as eligible capital facilities for the assessment of impact fees. As folks may know, impact fees are an optional tool, as outlined in the Innovative Land Use Control Statute 674/21, for municipalities to impose on new development to reflect the effect of development upon municipal facilities at the time of the issuance of the building permit. The statute currently lists a number of different eligible types of capital facilities, and specifically says construction or improvement of capital facilities owned or operated by, including and limited to. It's not an open-ended list. There's a lot of different facilities that were listed: municipal road systems, office buildings, water and sewer facilities, the share for schools, a number of different facilities, fire and police. But a community raised the fact or question last year of whether a public works facility, a DPW highway depot, a DPW salt shed, so on, would be an eligible capital facility. It was not explicitly listed, so this bill simply adds that a municipal public works facility is a eligible capital facility to assess impact fees for. Just a refresher, obviously, for a municipality to adopt an impact fee ordinance and an impact fee schedule and impose impact fees on applicants, it needs to have adopted a capital improvement program, a CIP, as authorized under RSA 674:5-7. And that change took effect August 1st of this year. Back to you, Tim.
Thanks. So this one's pretty simple. This amends RSA 91A to simply require that for the meeting minutes of a public body, that those meeting minutes include the start time and end time of the meeting and the name of the person who prepared the minutes. I didn't realize there were communities that weren't doing this anyway, but if you weren't, you're required to do that now. The only notable thing I figured to point out about this was that, as introduced, the bill would have also required the signature of the minute taker, but I guess it was determined at some point that that was an old-fashioned requirement and was kept out of the bill in its final form. But it's relatively straightforward. Back to you, Noah.
Great. The next bill is House Bill 272, exempting certain agricultural practices from municipal noise regulations. This bill modifies a previous bill, 2023 House Bill 252, which prohibited any noise or quiet hour ordinance or bylaw from prohibiting the regulation of noise from farms, agriculture, and farming as defined in RSA 21:34-A. Since the passage of that law and House Bill 252 took effect, some communities tried to continue regulating noise from farms, agriculture, and farming through disturbance of the peace laws. So this bill, House Bill 272, simply amends RSA 3139, paragraph Roman numeral 1, subsection N, and the which is in the other statute for bylaws for towns, RSA 47:4017, to prohibit all ordinances or bylaws from regulating noise related to farms, agriculture, and farming. To leave no doubt that there's no type of ordinance, municipal ordinance, can regulate farms from noise from farms, agriculture, farming. However, noise from agritourism activities defined in RSA 21:34-A, Roman numeral 2, can continue to be regulated as it was previously. And that change took effect on August 1st. Back to you, Tim.
Thanks, Noah. House Bill 296 relates to RSA 674-41, which, as you probably all know, provides that a building permit can't be issued unless the lot on which the building is proposed to be constructed has some sort of street access or frontage. And there are different options under 674-41 that can be satisfied to meet that requirement. And one of those relates to private roads. And so currently under the statute, if you're proposing to build a structure or a building on a lot that has access or frontage on a private road, the statute allows the governing body to authorize the issuance of building permits on that private road. Currently, they can only do so after review and comment by the planning board, which seems to make sense, and that would seem to be sufficient. But there was felt apparently to be a need to have an alternative to this planning board review and comment, and so now a governing body is now authorized to issue building permits on a private road if and forego the planning board review and comment if it's established a policy relative to issuing building permits on private streets or that particular private street, and the governing body finds that the private road identifies with whatever policy it's adopted. So it's not really clear what this statutory amendment is, what problem it's intending to solve. It simply allows it simply allows the governing body to remove the planning board from the decision-making process relative to issuing permits on a private road, but at the same time, it then implicates an additional step, which would be that you'd have to the governing body would have to first adopt a policy, some sort of private road, private street policy, and then once they've done that, then they can choose to allow issuance of building permits on a private road, as long as it's consistent with the policy that they adopted. So I'm not sure what practical effect this has, other than to, again, potentially remove the planning board from any advisory role at all relative to issuing permits on a private road. Secondarily, sort of on an unrelated note, the bill also clarifies the appeal period for administrative decisions. So, any administrative decision that's made relative to the zoning ordinance can be appealed, or needs to be appealed first to the Zoning Board of Adjustment. And the appeal period was defined previously as the appeal needed to be made within a reasonable time of that administrative decision having been made, and said, as provided by the zoning boards, the local zoning board's rules of procedure. So the local zoning board's rules of procedure could have identified probably a wide variety, compared to different communities, of potential timeframes within which you need to appeal administrative decision: 15 days, 30 days, whatever is reasonable. But now the statute clarifies it's within 30 days, so there's no more discretion left to the local zoning board to determine what that time frame is. It's now 30 days. Once the administrative decision is made, that when an administrative decision may be made that's appealable, that can become a tricky and gray question. But if it's clear when the decision's been made, then you have 30 days to appeal that to the zoning board, assuming they have jurisdiction over the decision that was made. So with that, I'll turn it back over to you, Noah.
Great. Thank you, Tim. And we are starting to get some questions, which is great. Tim, there's a question in there for you if you want to try to answer that in the chat. Voila, you can just type an answer on private road minimum road standards. So next bill is House Bill 399, establishing a commission to study the New Hampshire Zoning Enabling Act and relative to the effective date of the CPACER program. We're just going to focus on the first part, which is the Zoning Enabling Act Study Commission, which is a new 11-member study commission consisting of 6 legislators, 4 House members, 2 senators, as well as 2 national housing policy experts, a member of the public, a member of a municipality, a member of the judicial branch. I think I got everybody there. But notably, there's no actual named planners on this commission. The commission has a broad mandate to study whether the grant of zoning power in RSA 674-16, which was originally adopted in 1925, which comes out of the Model Standard Zoning Enabling Act that the U.S. Department of Commerce published, is still needed, and if there's other changes that need to be made now that 100 years later, as well as whether the purposes of zoning in 674, the additional statutes in section 17 through 23 are still needed to address the health, safety, and general welfare of the community today, and to recommend potential revisions, as well as to look at the relationship between the zoning powers and the power to regulate subdivisions as outlined in 674-35. I am actually a member of the commission. We had our first organizational meeting on August 20th. Then interim report will be due November 1st of this year, and a final report will be due on November 1st of 2026. It's a very good kind of thoughtful group of people that have been named to the commission. So it'll be interesting to see kind of what are the final findings that come out of the commission. Tim, back to you to talk about House Bill 413.
Great, thanks. This one is a little troublesome. Not at first blush. At first blush, it's clear and straightforward, and probably makes quite a bit of sense. And so currently, under RSA 674-39, approved projects, subdivisions, site plans are exempt from changes in land use regulations for a period of 2 years. At which point, if the project achieves active and substantial development, and that's a whole other conversation, the project is then exempt from any additional changes to the land use regulations for another 3 years. And so if the project achieves substantial completion within 5 years of the date of approval, it will have been exempt from any changes to the local land use regulations that were enacted in between the time of the original approval and the time of substantial completion. And then moving forward prospectively, forevermore, the project as it was approved is likewise exempt from any future changes to the land use regulations. What House Bill 413 does is very simply to extend those timeframes. So it extends the time to achieve active and substantial development from 2 years to 3 years, and it extends the time to achieve substantial completion from 5 to 7 years. So that's pretty straightforward, I think. But there was a question as to, well, how does this apply retroactively to projects that have already been approved and haven't yet achieved substantial completion? I think in an attempt to be helpful and to try and address that question and to draw a line, a new paragraph was added to 674-39 to provide that the 7-year period and 3-year exemption in this section shall apply to any approval granted on or after July 1st, 2023. Great. But the problem is that the 7-year period and 3-year exemptions in the amended statute weren't additions to the 3 and 5 years. They were replacements for the 3 and 5 years. So effectively, with the changes to 674-39, the statutory exemption periods for any project that was approved prior to July 1st, 2023 appear to have been eliminated. There are no, for any project that's been approved by your planning board and has not yet achieved substantial completion, it apparently has no statutory exemption. I presume this was an oversight. The Hampshire planners didn't catch it. I reviewed the municipal association's comments on this, and they haven't pointed this out. This needs to be fixed because the questions and problems that this raises are pretty substantial. So, for example, it's not clear. It's not clear what local. If you have local regulations that identify, 2 and 5 year timeframes to achieve vesting, it's not clear whether those necessarily can be used to sort of fill in the gap and to automatically apply to projects that were approved before July 1st, 2023 and haven't achieved substantial completion. I think there are a lot more questions around this than need be if it was simply, and we could sidestep all those potentially thorny legal questions if the statute's just clarified to make it clear that the old deadlines, the 2 and 5 year deadlines, apply to all projects that were approved prior to July 1st, 2023. So I think this needs to be fixed very soon. But in the meantime, there's a very wide open gap here. So for example, if there are communities that rely exclusively, if your land use regulations rely exclusively on the statute for the vesting periods, then presumably, again, there's no vesting for any of your projects, and any changes to the land use regulations that have been made since those projects were approved, they have to be complied with. Like it's not discretionary. And so if there certainly could be projects out there that have been approved and based on, zoning amendments that have been enacted since then, those projects are no longer zoning compliant and they're dead, potentially. So there's a lot of very thorny legal questions that have been raised by this unfortunate oversight. So good luck with that. Back to you, Noah.
Thank you, Tim. The next bill we're going to talk about is House Bill 457, relative to zoning restrictions on dwelling units. This one also raises some interesting questions as well. So this amends RSA 674-16, again, the zoning grant of power, to add a new paragraph, Roman numeral 8, which does two things. It prohibits the adoption or enforcement of ordinances that restrict the number of occupants of any dwelling unit to less than 2 occupants per bedroom. So if there was an ordinance that said you can only have 1 occupant per bedroom in a house, that's no longer allowed. The other thing it does is it prohibits adoption and enforcement of ordinances based on the familial or non-familial relationship, marital status, occupation, employment status, or the educational status, including but not limited to scholastic enrollment or academic achievement at any level among the occupants of the dwelling unit, including but not limited to college students. A lot of these issues were already in the anti-discrimination statutes as well. And so really, simply put, this is having to do with the relationship of the occupants of the building. And it talks about the number of occupants in the bedroom. That is what the bill does. That will require some changes for some communities that have had a cap on the number of unrelated persons that have no familial relationship from living together. However, what it does not do is it does not affect municipal authority to impose a cap on the total number of dwelling units in a building. So if you want to put a cap of, say, 10 units or 10 bedrooms even in a house, you can keep doing that. It also does not cap the total number of occupants in a building. As long as your number of occupants divided by the total number of bedrooms is still allowing for at least 2 persons per bedroom. And also maybe, and this is the most important part, it does not mandate any specific land use or change to local authority to regulate any specific land use, specifically congregate living, rooming or lodging houses, sober homes, dormitories, or other group living where occupants have a private or semi-private room but share a kitchen and bathroom facility. It only regulates the relationship of how the people in the building are related. It doesn't regulate the land use. So if you list out separately right now in your zoning ordinance, dormitories, fraternities, sororities, other congregate living facilities like nursing homes, any other type of group living situation, you can continue listing those as separate land uses, and and if you want to keep prohibiting those land uses in any zoning districts, you can continue doing that. This bill does not change that. And it also does not affect building or fire code occupancy requirements. And the effective date of House Bill 457 is September 13th, so just about a week ago. The next bill, and there's a lot in here that probably folks have heard, is House Bill 577, which is relative to modifying the definition of accessory dwelling units. I think most folks have heard at this point that as amending to require that one attached or detached ADU be allowed as a matter of right in all zoning districts that permit single-family dwellings. This is a significant change to previously the ADU statute in 674-72 gave the option for a municipality to only have to require one attached ADU, and a municipality could choose how it allowed that attached ADU, whether it was allowed as a matter of right by a conditional use permit from the planning board or via special exception from the zoning board of adjustment. In order to accommodate the requirement that both a attached or detached ADU be allowed as a matter of right, The definition of accessory dwelling unit was also amended in 674-71 to say that an ADU is an accessory dwelling unit on a lot. What is very interesting, though, is that, and whether it's a huge issue or not, I think remains to be seen, is it defines an ADU completely contained within a pre-existing detached structure as an attached ADU as opposed to a detached ADU. For the most part now, House Bill 577 is treating attached and detached ADUs in the exact same fashion. So it's not clear to me that while that wouldn't seem to make logical sense, remains to be seen if that's really going to kind of pose an issue, but it is at a minimum kind of defies logic a little bit. Some of the more kind of finer details in here that I want folks to pay attention to are that the ADU law also adds new language in 674-72, Roman numeral 1, that an ADU may not be subject to setbacks, aesthetic requirements, so the location of the primary entrance or exit of the ADU, paint color, design review requirements, as well as lot size, frontage, space limitations beyond what is required for a single-family dwelling. As well, statute kind of reinforces in a later section as well, the aesthetic requirement change is significant. You could previously allow conformity of the aesthetic of the ADU with the principal dwelling unit. As we'll talk about again in a second, it's now very clear that if you're not applying any aesthetic standards for the principal dwelling or the single-family dwelling, you cannot also apply aesthetic standards to the attached or detached ADU. There was also language added to 674-72:1 that explicitly prohibits municipalities from imposing septic system requirements for a single-family home with an ADU that are greater than required by DES. And the language about municipalities being allowed to prohibit ADUs with a manufactured housing was replaced by language that says that a municipality can prohibit ADUs associated with rented or leased land. So this would be most likely a manufactured home in a manufactured home park. The next section that was changed in the ADU statute in 674-72 is in Roman numeral number 3, which replaces the previous interior door requirement, and that the interior door had to remain locked, with a more general requirement that if it's an attached ADU, it needs to have an independent entrance or exit, ingress or egress, or through a common space, a shared hallway, shared with the principal dwelling. However, the municipality cannot limit that choice of ingress or egress. So, whereas the statute previously said municipality could say you must have a common hallway between the ADU and the principal dwelling unit if it was attached, or you must have a door leading to the outside. Municipality cannot deeply really kind of place as much restriction on that location of the entrance and exit so as to limit the location of the ADU anymore. The next sections, a couple more sections on the ADU bill, are that it kind of clarifies in Roman numeral 4 that municipal regulations applicable to both a single-family dwelling and ADU shall not be more restrictive for the ADU than for the single-family dwelling. There's also a new requirement that municipalities shall require no more than one additional parking space for each ADU if it established regulations pertaining to parking for the principal dwelling unit. And in addition, it also says that it's the discretion of the property owner to determine whether the parking space for the ADU is provided either on site or at a legally dedicated off-site location. But that's up to the property owner and not the municipality to determine. The owner occupancy, the option to require owner occupancy of either the principal dwelling unit or the ADU in Roman numeral 6 is still there. And then just two other changes to point out here are that, again, I talked about earlier, this is where the repeated the language specifically now says in 674-72 Roman numeral 7 or VII that says that, again, as before, you could require aesthetic continuity between the ADU and single family dwelling. You can now only allow aesthetic standards for the ADU if you also require aesthetic standards for the single family dwelling. And then finally, it makes some adjustments to the size requirements. I think there's been a lot of the languages introduced said that a municipality had to allow an ADU up to 950 square feet, whereas previously it was 750 square feet. The final version that got adopted added says up to 950 square feet. A municipality can allow larger if it wants to, but it's not required to. But then it also has this language that says the municipality cannot limit to less than 750 square feet. It's a little bit confusing. Not we have to go by the legislative intent here initially, which was to require ADUs, larger ADUs in the original statute required, so up to 950 square feet, but not limit a municipality to not allow really, really small ADUs that were, say, 400 or 500 square feet. So this language about the 750 square feet, it's a little bit confusing. It got added on in the end. But again, I would say really the 950 square feet limit is where the legislative intent was to go. And I'm sure we'll have plenty of commentary on the size, square footage in the chat. Please, I'm still struggling with that interpretation myself. The final section I want to point folks to here is that there's also a new requirement in 674-72, Roman numeral 11, that says existing detached structures that are being converted into ADUs do not have to meet setback or lot coverage dimensional standards. So basically, if it's a non-conforming structure, it can still be converted to an ADU. It does not need a variance to be converted into an ADU. All that said, kind of a couple things, big picture. Applicant is still required to pull a building permit, make adequate provisions for water supply and sewage disposal in accordance with DES requirements in 485A:38, and have an approved septic design from DES. And I would say municipalities should also be prepared for receipt of building permit applications to construct an ADU, even if your municipality has not had the opportunity to amend your ADU ordinance. It's not necessarily going to prevent somebody from coming in and say, "Oh, the state statute was changed and went into effect on July 1st, and I have a building permit application that complies with all those state statute changes for an ADU as written in House Bill 577." We'd encourage you to speak to your municipality, speak to your municipal attorney or council about how to address these situations. Generally speaking, state statute does preempt your local zoning ordinance, but understand, again, we're going to say you should definitely talk to your municipal council to the degree that these situations start to occur. The next bill we're going to talk about is House Bill 631, permitting residential building in commercial zoning. This broadly requires a new section in 674:80, which requires multifamily residential development as a use to be allowed on commercially zoned land, which 674-79 defines as land zoned for such commercial activities as retail and office space. Provided that, and then 674-80 Roman numeral 1 goes on to say, provided that adequate infrastructure, including roads, water, and sewage systems, shall be available or provided to support development. The statute, however, does not actually says including roads, water, and sewage systems, but it doesn't limit it to that, and it doesn't say what kind of set benchmarks for adequate infrastructure. So municipality will need to define what constitutes adequate infrastructure. And then the planning board will need, if it gets an application for multifamily development in a commercial district, commercial zoning district, to determine whether the adequate infrastructure is actually present to support that development. And in order for the applicant to be able to permit it to go forward with that development. And in making that assessment of whether adequate infrastructure is present, a planning board still has at its discretion, and I would encourage municipalities, planning boards to continue to subject those multifamily developments to site plan review or mixed use developments to site plan review. There's nothing in 631 that prevents that. There's also nothing in 631 that prevents applications for new construction of multifamily residential developments or mixed-use developments from being subjected to your zoning ordinance's existing dimensional requirements, whether that be height requirements, setback requirements, frontage requirements, lot coverage requirements. The only thing the statute says is that for existing buildings being converted to multifamily or mixed use through adaptive reuse, those are exempt from setback, height, or frontage requirements, provided the building's floor area, height, and setbacks do not change. But that exemption does not apply to new construction. So at the end of the day, 631 is really saying for new construction, you have to allow the use of multifamily in commercial districts, but you can continue to regulate it and put limits on how you're allowing multifamily. It also says that a municipality can prohibit residential development in zones that might be commercial industrial districts where there's both industrial and commercial uses are permitted. If there's a concern that the industrial manufacturing uses may result in impacts that are incompatible with residential use, such as air, noise, odor, or transportation impacts. And it also leaves up to the municipality the discretion to require all available ground floor space or percentage thereof dedicated to retail or similar uses. So, in the end of the day, this is going to require some changes in zoning ordinances. This change, unlike the ADU law, House Bill 577, which took effect upon signing, does not take effect for another year. So until, or a little less than a year at this point, until July 1, 2026. So we'd encourage folks to amend your zoning ordinances accordingly. However, that won't take effect till next July. Back to you, Tim, I believe. Where a lot of great discussion in the chat. We are running long on time, so we're going to try to get through the last couple of planning and zoning bills here relatively expeditiously before we move over to the next parts of our presentation. Tim, I'll turn it back to you.
I'll go quickly on this one. Again, 674-41, different options for road frontage. You provide that road frontage, the municipality can then issue a building permit for a lot on that road. Relative to Class 6 roads, previously, or I should say currently, the effective date of Senate Bill 281 is not until July 1st, 2026. So if there's any appetite to change this, there's an opportunity to do so in this upcoming legislative session. But very simply, what this does is to remove the discretion from issuing building permits on Class 6 roads. So currently, it's really a policy matter. Will the governing body decide to issue building permits on this particular Class 6 road or not? And part of that process is including planning board review and comment. Under Senate Bill 281, again, which will be effective as of July 1st, 2026, there's no longer a choice in the matter. The municipality must issue a building permit to construct a building on a lot that has frontage on a Class 6 road if a liability waiver is signed and recorded, and if the applicant demonstrates that the lot and the buildings are insurable. We could have a longer conversation, of course, and discussion about exactly what those things mean and what the implications are, but that's very simply what it provides. And again, it's not in effect until July 1st, 2026. Noah?
Sorry. Next one is SB 283, which is relative to the calculation of floor area ratios under local building ordinances. This simply says, adds a new section to 67477 that defines floor area ratios as the ratio of a building's total floor area to the size of the parcel of land upon which it is built. There's relatively few communities that are using floor area ratios. So if you're not using floor area ratios in your zoning ordinance, you can ignore this one. Generally, floor area ratios or FAR affects the volume of buildings on the lot, but does not by itself determine a particular shape, spacing, or height of a building. 67478 Roman numeral 1 states that when you're determining floor area ratio, you now must exclude the below grade areas from that calculation. So basements, cellars, sublevels, meaning that if they're not habitable space, you can't include that in that ratio. I'm not aware of an instance in New Hampshire where this was happening, but theoretically, by including those areas, that could reduce the amount of buildable space, of buildable and habitable space. However, the statute also says in the second paragraph of 67478 that developers may continue to utilize below-grade areas for purposes such as parking, storage, mechanical spaces, and additional facilities without impacting the FAR. And this change takes effect on September 30th. I think we got one more. Billy, I'll turn it back to you, Tim, before we turn it over to Mike.
Thanks. This one's pretty straightforward too. In 2024, the zoning ordinance enabling statute was amended to specifically provide that municipalities can regulate parking through the zoning ordinance, and at the same time imposed a limit for certain residential units, including workforce housing studio and one bedrooms under 1,000 square feet and multifamily developments of 10 units or more. That with so that with respect to those specific residential uses, the local zoning ordinance or your local regulations could not require more than 1.5 parking space per residential unit. Just a year later, that language has now been removed, and a blanket prohibition on any local regulation or requirement of more than one parking space per residential unit. So again, whether you want to require one parking space or half a parking space per residential unit, it can't be any more than one. It's as simple as that. The only other thing I thought to point out was that that alternative parking solution that was also adopted in 2024, which is a very strange provision. I don't know if any of you in your communities have utilized that yet, but it's 674-16A. So even that still applies. So if you had a one parking space per residential unit requirement in your zoning ordinance or your site plan regs, an applicant could still try to utilize 674-16A to obtain an even lower parking ratio from the planning board through that process. So that's it on that one. Noah or whoever.
So next we're going to hear from Michael Hagan with the City of Keene. Mike, you take it away.
Great, thanks, Noah. Great job. It's a lot of changes this year. So some stuff on the building side, a lot of building code changes. Some good, some things we're going to have to do to change our practices. So again, Mike Hagan with City of Keene, also the Vice President, New Hampshire Building Officials Association. So I'm going to try and take control here. Which I did. Okay, so these are the 6 bills I'm going to go over. I tried to put links on each of these so that when you have this available to you through the BEA website, that you'll be able to click on them and see them. All right, so the first one we're going to go over House Bill 134. So 134 is the annual bill for the BCRB. Each year, when I first started with the Building Code Review Board, we used to ratify the building code, or it would be the Building Code Review Board would approve the building code, and then it would be ratified within 3 years by the legislature. That went away in 2015, and now it requires that all of the amendments and adoption of code be done through legislation. So we have a standing bill with ED&A. Obviously, it changes every year. Last year it was House Bill 1050. This year it's 134. One of the updates that came along with that is the 2023 NEC. It was approved by the board with a total of 19 amendments to that code. There were 4 other amendments that went along with that, and the effective date. So when the board met, we had these amendments up to April 11th, and the effective date was July 1, 2025, even though it didn't get signed until July 15th. So it was kind of a weird limbo, but it did go effective with a concurrency date of July 1. So with the adoption of the new code, if a project was already in process or in works, it can be reviewed and approved under the 2020 National Electric Code. If you choose to go with the 2023 because there's some beneficial requirements or some amendments that affect a project, you can opt to go with it. So you can, the builder has a choice to go with either one. The next bill, Tim and Noah talked about this. There was a portion of this that was added in to that House Bill 413, which has to do with appeals. And you'll see on the next one going down, I just tried to keep them in numerical in order of the bills. So for the ZBA, if the ZBA acts as the local board of appeals, it can only hear appeals of local amendments. It can't hear appeals on the building code. That will have to go to the Building Code Review Board now. That's as effective as of July 1. And it also, if you don't like what you've heard from the Building Code Review Board, you have the option of appealing it also to the Housing Appeals Board, in addition to Superior Court, as always. House Bill 228. So this one, this kind of went away with municipal amendments. All right, so we can no longer change the state building code. Last year, there was a bill that was put into place that all municipal ordinances had to be approved or confirmed by the Building Code Review Board in regards to the building code, to make sure that none of the ordinances were less stringent than the state building code. They had to be either higher but they couldn't be less stringent than the minimum requirements of the state building code. So in the city of Keene, we used to have no roofing permits or no siding permits. That is no longer the case because of last year's bill, where it said you couldn't be less stringent than the state building code requirements. So you have to issue, if you have an enforcement mechanism, you shall issue permits for those types of anything that's regulated under the building code requirements as a minimum for the State Building Code Review Board or state building code. The other one is the just these notes are pretty big. Hold on once, I apologize. So it limits the local amendments to basically the issuance of permits, collection of fees, or similar administrative functions, but no technical amendments. So the municipal technical for municipal technical amendments are allowed where the state building code is more than 2 editions behind. The published code, model codes, including in the state building code, are not less stringent than the current state building code requirements and have been confirmed by the State Building Code Review Board. For the state fire code, the local legislative body is limited to adopting administrative amendments relative to issuing permits, collection of fees, and other administrative functions. No amendments to technical requirements of the state fire code are permitted. Important to note, municipalities are permitted to adopt nationally recognized codes not included in the state building codes. So you see the suite of codes on your screen. If you chose to adopt the property housing and safety standards, the International Code Property Housing Safety Standards, or the International Zoning Code, which would probably never happen in the state of New Hampshire, but they do have that available through that. So that's the first portion of this. The second portion is enforcement authority. What the Building Code Review Board tried to do or help with this bill was to move some of the legacy statutes out of the 670 series, 674, 675, 676, 677, all of those sections, 678, and try to get them where they pertain to building and building enforcement, so that they were in RSA 155. So in this move, there were 2 sections that were added to that, and that's the 2 sections that were moved was 4722 and 67451. And it's effective for July 1, 2026. The reason for this is that there's also another bill that deals with some of those other legacy statutes or enforcement for building codes and that are in the land use codes that are going to be brought into 155, but it was held over for this coming session. So it had a summer session. That was actually some of the new language was reintroduced recently, and I think there's a hearing in a couple of weeks on that with those changes, adding to those 670 series changes. The next one is Senate Bill 95. Senate Bill 95 deals specifically with youth summer camps as defined in RSA 170E55. So it permits summer camp cabins without sprinklers and does not require plumbing, mechanical, or electrical systems if not provided. So if it's provided, then it has to conform to the code requirements. If it's not provided, then it doesn't have to conform. And this is effective September 13th, 2025. And again, this is limits only to youth facilities, not some of the other types of summer camps that you'll see. This is probably one of the biggest bills that I worked on this legislative cycle. This was called the Speeding Development Act. So Senate Bill 188 was the Speeding Development Act of 2025. The way it was originally written, basically, I'm going to cliff note paraphrase for you. It basically allowed developers to choose a third party or approved agency to act as the building official for a municipality, and they could choose whoever they wanted. There was no oversight or regulation, or very little at the time when it was first written, to the municipality having any say in who is approved or qualified to conduct these inspections and plan reviews. And there was no mechanism at the time for the municipality to collect any fees, even though they were still required, as it was originally written, to the developer would choose a third-party agency. The third-party agency would submit an application. The application would have to be issued within 5 days of receipt. So it would come into the municipality. You'd have 5 days to issue a permit. You had no say in it because it was approved, reviewed and approved by this third-party entity, and they provided a certificate saying that they reviewed and approved it. And basically, the municipality would have to issue a permit, or otherwise it would be issued by default within 5 days of receipt. Then after that, they would conduct all these inspections, submit a inspection report or a final report with, again, very little oversight of auditing. And then the municipality would have to issue a certificate of occupancy within 5 days after that receipt of those. This is in direct conflict of a lot of other statutes in the state, as well as the building code, the state of New Hampshire building code. So we worked with BEA, we worked with the New Hampshire Municipal Association as part of the New Hampshire Building Officials Association, as well as with the New Hampshire Home Builders Association and Association of General Contractors, and with multiple senators to massage this bill to a point where it could be used and not be in conflict with other. It's not a great. It does limit, but it also allows municipalities to, one, approve the third-party agency, make sure that they're actually capable of doing what they say they're going to do. So we get that information in, and we did a great guide, which I'm going to continue on to the next slide. But in these slides, you'll see the links for it. You'll see how it was amended. So as part of this legislation, the New Hampshire Building Building Code Review Board needed to make an amendment in the building code to allow for these third-party reviewers, and actually written it into the code as an amendment for the state of New Hampshire, was approved upon writing of it or approval by the board. And with NHMA and the New Hampshire Building Officials Association, we wrote a document. It's a 5-page document, so I didn't want to read the whole bill to you, but it's a 5-page document that goes over all of the responsibilities for this in order to do that. So it goes over the application and approval of the third-party agency. So municipalities retain the right to approve or deny them. Now, if you deny them, you have to deny them in writing and for just cause. That's the way the bill is written. So it's up to you to decide what the just cause is with you and your attorney. But if they have the 3 currently approved agencies would be a licensed architect, a licensed engineer, or an ICC certified building official. So those are the 3 approved agencies written into statute. It goes over that in this guidance document. The guidance document also breaks down the approved or the obligations for the owner, that they are not, that there's the indemnification statement to the municipality by using this third-party agency, and that there's the contract and payment information. They authorize that, and they pay them directly for these services, for the plan review service and for the inspection service. The next portion is the approved agency services and scope. This goes over completed documents that they have to certify that they examine them and that they meet the state of New Hampshire code requirements. So affidavit of compliance, the inspections and what's on the inspection report have to be detailed and complete. That information checklists for what they have to accomplish. And then the next is municipal responsibilities. So the one thing that we did put in here, because there is time in processing building permits, making sure that there's the coordination between the planning department, the zoning department, the floodplain department, the health department, if there's a restaurant in a hotel, or so on and so forth, the fire department, and Public Works Department for hookups. So there's a process that goes on behind the scenes that a lot of these developers don't or don't see, and that there is a cost for doing that in issuing a building permit, and is usually recovered by those fees. So the other thing that is important is there's a 40%, you have to provide a 40% fee discount for all plan review services. So if they only choose to use a third-party plan reviewer for the project, there's a 40% discount on your fees for inspection services. And the municipality can retain 20% for the administrative services. So if they choose to go, if they choose to only use one or the other for either the inspection portion or the plan review section, you retain 60%, but at all times you retain at least 20% of the fee based on your municipal fees. So you may want to take a look at that and what you're charging now to see if that needs to be adjusted to process the paperwork. The other thing is access to related documents. You have to provide the third-party reviewer access to your software so they can enter inspections. There is some, you can provide any limitations or if you want to have them put it in writing and then you enter it in the system as part of the documentation. The other part that the municipality has is for audits. This is an important part. Audits may be conducted only after a building official has created a formal audit evaluation. So there's some, what we've done is on this guidance is how do you do that? What's the process for that so that the municipality can be prepared for that? And then prior to the notice, there's also the, you can do it no more than 5 times a month. So if you want to audit this inspector as part of the process, and you feel that the project, you can go to the site as you still have the municipal right to go to the site and conduct audits up to 4 times a month. And then there's a process for if you find that what they've inspected is not approved, there is a process for suspension of an approved agency. There are timeframes. We also wrote in there that they go to the appropriate boards. So for if it's a third-party agency that's an architect, it has to go to the architectural board. If it's an engineer, it goes to the engineers board. If it's a certified ICC certified building official, it would go to the building code review board. Insurance, the issuance of building permit, we changed that date from that 5-day stringent 5-day period to 14 days. We also changed the time frame for written deficiencies to 14 days, as well as the denial of the permit has to be done within that 14-day period. And then they did, so certificate of occupancy at the end of a project. You have to issue that if all the documentation is in order. You have to issue it within 10 days of the completion of that project. So there's 5 pages of guidance document on that. It's also written into the amendment through the State Building Code Review Board. It's in the state building code as well. So I know there'll probably be a lot of questions on that. One of the big things that may or may not happen with this is there is a pretty steep insurance requirement for these third-party approved third-party agencies. There's a dollar amount, you can look it up. I won't go through it, but for a certain size project, they have to be insured for this amount. From what I understand, some agencies looked into this after this bill passed, and the cost of insurance was pretty exorbitant for that. I'll try and speed up here. I believe this is the second to last one. Senate Bill 282. This one allows for single exits in a 4-story residential building. This is not uncommon throughout the country now. We're seeing this in the 2027 codes that are going on right now at the international level, or at the International Code Council. They're writing this in already for the 2027s. There are other municipalities like the city of Seattle, Washington, allows up to 6 stories for with a single exit stair with a bunch of conditions on it. The state of New Hampshire, through the State Fire Marshal's office, worked diligently on this amendment or this bill proposal, and then a building code amendment to allow for this. Just to give you an example, it wasn't a huge change from what already is allowed today. They under the old state building code requirement, it allowed up to a 3-story residential building with a single exit stair. The only thing that's changed is it went from a 3-story to a 4-story with this legislative change with the Senate Bill 282. 4 conditions. It has to be an R2 use group, maximum of 4 dwelling units per floor, maximum travel distance to exit enclosures 125 feet, and an automatic sprinkler system is required. That will limit a lot of places where this can be used because a lot of municipalities don't have water and sewer or water services. So this is just that amendment as written with the State Building Code Review Board. So again, going from a 3rd story to 4-story. And yeah, I think that is it. Thank you. I think it's taken over.
Yep. Thank you so much, Mike. We're now going to, lastly, thank you everybody that stuck with us, hear from Phil Trowbridge at the Hampshire Department of Environmental Services.
Good afternoon, everyone. I'm sure you're tired, so I'll go very quickly in my slides, trying to highlight some changes that are occurring relative to land use permitting at the state level and how they may be useful for you all at the municipal level. All right, let me just get my mouse on the right screen here. Where is it? There it is. Okay, so first off, what my job here at the state is to manage the land resources program. This is the program that does wetlands permitting and subsurface shoreland permitting, alteration of terrain permitting, and septic system and subdivision permitting. So we're mainly a permitting shop, and that's reflected in the slide here. We process 10,000 permits a year. But we also do other things. We respond to a lot of questions from people from anything from, do I need a permit for that to, my neighbor is doing something here that I'm not sure if it's legal. We investigate complaints, and we also award restoration funds for projects that benefit wetlands. This last budget session, the trailer bill to the budget, HB2, had a lot of changes to land use permitting that affected my program. The HB2 is the governor's bill, so the objectives were set by the governor for what she wanted to achieve. And specifically, the goal was to try and consolidate permitting programs that were spread across multiple agencies under one roof. And the purpose of that is to speed up permitting decisions and to have better coordination. All of this, of course, is prompted by the housing crisis and the need to speed up permitting. So what I'm going to cover today is 3 changes that have occurred as a result of that budget bill, and try and highlight where they might be relevant to the municipal processes that you are involved with. So the first one, I'll be talking about some new permit by notification options for the alteration of terrain program. Second topic will be the process that we're going to be using for protected species. These would be threatened and endangered species. And finally, we'll be talking about some fee increases for our permits. So big picture here, the alteration of terrain program is our stormwater management program. It deals with large projects. Think of the big box stores, 20 to 30 unit subdivisions, that kind of size of project. Technically, it's required if you're going to disturb the earth more than 100,000 square feet, which is about 2.3 acres. Up to now, there'd been only one way to get an alteration of terrain permit, and that was through the standard application. You would write up all your plans. Those plans would undergo a technical review here by the state, and then would be approved. The objective of HB2 was to try and speed that process up for the smaller of the projects. So they created this permit by notification process for projects that disturb between 100 and 150,000 square feet. So those just basically the low end of the scale of projects that we deal with. And the permit by notification is different in that the state doesn't do a technical review. The applicant needs to certify that their project meets the state rules. And our role is to verify that the project meets the eligibility requirements for the PBN. And if it does, then we turn around and give our approval within 14 days. That's quite a bit faster than the 50-day review that we do for the standard applications when we need to do the technical review. This process is not eligible for certain projects, one of which is if the project it has any portion in the protected shoreland, it would not be eligible for this permit by notification. Projects that are earth mining activities, such as gravel pits, would not be eligible. Anything that is an after the fact project where someone has done work without a permit and then is seeking permit coverage after the fact, that would not be eligible. And then finally, and most importantly, projects that require a waiver to any of our rules would not be eligible. So this is really for people who come in and know that they can build the project within the rules and don't need any waivers. And it meets, it's within the size limits of the PBN and doesn't protect the protected shoreline. The fee for filing is $3,125, which is quite a bit less than the applications that require our technical review. Now, one of the reason I wanted to bring this up to you all is I know a number of municipalities, look to alteration of terrain permitting when you're reviewing your projects at the local level. So you should be aware of this distinction between the projects that are going to have the technical review from DES, which would be projects over 150,000 square feet, or projects that are under that amount that don't meet the eligibility requirements, versus the projects that are the permit by notification. There is one other PBN that was created. This one was created by Senate Bill 65, and that bill was focused on making development of solar projects a little bit easier. And so the eligibility for this PBN is solar projects of up to 5 megawatts in generating capacity. That is, of course, electrical terms. In terms of real land, that's about 20 to 30 acre sized fields. The same eligibility requirements that I talked about previously apply. Particularly impacts to the shoreland and waivers. So this is going to be a simpler process. We're not sure how often this is going to be applied, but it is an option for some of these smaller solar sites. Second thing I want to discuss with you all, it relates to ecological reviews for protected species. This is there's really the meat of the changes in HB2, and the big picture here is that the state has obligations under RSA 212A and 217A to protect threatened and endangered species, and the state. Part of those statutes say that state authorizations of work have to take into account steps or conservation measures to protect those species. So when we issue a permit, like a wetlands permit or an alteration of terrain permit, we're authorizing that work. So in the past, the process has been that someone would apply for a wetlands permit or an alteration of terrain permit with us. There would be an indication of protected species in the area from an online tool that we use, and then we would then tell the applicant that they needed to consult with Fish and Game or Natural Heritage Bureau to get recommendations on how to protect those species. Now, of course, that is one of the things that was confusing to applicants because they're dealing with 3 different agencies, and there's some time lags associated with working with between the 3 different agencies. So what HB2 did was to move the permitting aspects for threatened and endangered species from Fish and Game and from Natural Heritage Bureau and move them into DES, so that it's basically the one-stop shop that was the goal, the governor's goal for HB2 for this activity. So what will be happening is, we will be managing the data check tool, which is the online tool that people can use to figure out if there's a species in their area, and then also doing the initial screening and ecological reviews for these projects, and then getting those recommendations into the permits that whether it be a wetland permit or an AOT permit. And then, there's still some interaction. There'll be still some reviews that Fish and Game and NHB will need to do, particularly on state lands or projects that don't need permits. But for the most part, the work on this issue will be consolidated here at DES. So this was a big change. The process for this had been pretty straight. I guess status quo for quite a while, but we're trying to make this change be as seamless as possible. And one of the challenges for us is just that we're moving some staff from New Hampshire Fish and Game and Heritage Bureau to DES to make this happen. So far, we've moved about half the staff, and it's gone very well. We've had very little downtime on the processes, and we'll be moving the rest of the staff in a few months. We are already seeing the benefits of having the staff together, and we're getting good internal coordination. And we will continue to work with Fish and Game and Natural Heritage Bureau on coordination between the agencies. This QR code that we have on the slide here is to the new website that talks about our ecological review process. And so if you want to capture that, or these slides are available, you'll be able to get to that website. The next big challenge for us in 2026 will be following up on a mandate that was given by NHB2 for us to develop an in lieu fee mitigation program for wildlife impacts. Many of you, I'm sure, are familiar with the wetland mitigation program that we have called the ARM Fund, where applicants are able to pay into a fund for their impacts to wetlands, and then the state uses that money to do wetland restoration projects to achieve the no net loss objective. There's a desire to have something similar to that when you have impacts to protected species, and we will work on that in 2026. We are under no illusions that this is easy. This is going to be extremely difficult and much more difficult than the ARM Fund, because you're dealing with multiple types of habitats and multiple types of species that often have conflicting requirements, and the habitats aren't as well mapped as wetlands are. But we understand the mission, which is to make a more predictable system and come up with a process that people will be able to use going forward for development. Our first steps on this are to do listening sessions this fall so that we can learn about or learn from our stakeholders and other experts, and then use that to take a thoughtful approach to developing rules. So the last slide here, it relates to other changes in HB2 that were everyone's favorite, which was fee increases. This was the watchword for most of the budget session, was how to moving programs off of general funds and onto other funds. In our case, we lost 8 generally funded positions, and we gained 6 unfunded positions. So we had 14 positions that needed funding in order to maintain our services. That led to increasing the fees, as shown here, where alteration of terrain has doubled, Wetland fees increased by 50% for the most part. And then the charges for the data check tool increased to $50. The fees for subsurface also increased 50%, but it's slightly for a different reason. Those fees have been in place since 2009, so a 50% increase is just a catch up to where they should be with inflation. We did not have any changes to shoreland fees, so that's, I guess, the one bright spot, or black piggy bank, however you want to look at it. And so those were just the issues I wanted to cover with you all. I'm happy to take any questions, and we'll actually, no, I have a few other slides. Sorry about that. I did want to point out we have some rule updates that are going forward. If you're interested in these, the alteration of terrain and ecological review and subsurface rules will all have hearings in mid-October, and then we'll be looking at some wetland rule updates in 2026. This QR code here is our customer service survey. Any of you have had interactions with DES in my program in particular, we'd encourage you to scan this code with your phone, and just it takes about a minute just to say how great we are, and give us some feedback on your interactions. It would be much appreciated. And also on this slide are our social media channels, which we've spent a lot of time on, and in particular on YouTube. We have my program has its own playlist with lots of instructional videos. And okay, and then this is the last slide. So here's my contact information. I'm Phil Trowbridge. I'm the manager of land resources, and working with me here, we have Darlene Forrest for wetlands, Amy Clark for alteration of terrain, and Scott Hazelton for subsurface systems. Thank you for your attention, and look forward to hearing from you.
Great. Thank you so much, Phil. And thank you, everybody that stuck with us the full hour and a half. Here is all of our contact information if you do want to follow up with any of us individually with additional questions. Again, all these slides will be online, so don't feel like you need to note down each of our email addresses right now. Our next month's plan webinar will be on Thursday, October 16th at noon, and be about the 2025 New Hampshire Stormwater Manual, which will be folks from Phil's shop from DES, along with the engineering firm that worked on the updated manual. So please save the date for that. I want to, we have already gone an hour and a half. There's been a lot of great questions. So I don't want to keep folks here much longer. I think if folks do have additional questions, feel free to put them in the chat. I think we've done our best to try to answer them throughout Tim, myself, others. I think what we're going to do is we'll kind of try to consolidate all the chat. I think there's a lot of good responses in the chat into one document that we'll then try to recirculate in the next couple weeks that kind of summarize the questions and answers. But if folks do have additional questions, please put them in the chat now so we can formulate answers to those. Phil, while we have you, there was one question though about if there's been broad outreach on the fee increases.
Yes, there has been. There's more, more to be done on it. It was an unfortunate thing where HB2 was passed and signed by the governor on June 27th, and then the fee increases that were in HB2 went into effect July 1st, which, obviously did not leave a lot of time for outreach. So a lot of people were upset when the fees went up automatically, or went up, without much notice. But we've done our best to get the word out and explain, of course, the reason why we couldn't communicate about a bill that wasn't fully signed. And, of course, as we work with our customers, people are learning about it even more. But please let people know. More that we can do to get the word out, the better.
Great. I did see one or two more questions. I'll leave this open for folks to add any more questions into the chat now. Again, I want to thank everybody for coming. My colleague Alvina has put a link to the webinar survey, which we'll also include in the follow-up email as well. We'd encourage everybody to provide feedback. We know this has been a lot of information to digest. BEA will also be putting out some additional fact sheets on some of these bills. The Municipal Association, as was pointed out, has also put out a number of pieces of different guidance on both on most of these bills. So I encourage you to check that out as well as a resource. And I want to thank everybody for coming today. And have a great afternoon.